Vacation list, item number 1.
May I please, Your Lordship. The petitioner challenged the arbitration auction sale notice dated 26/9/2024 for the bank.
Yes.
Auction sale notice dated 26/9/2024 issued by the opposite party number 1.
Yeah.
Lordship, the petitioner unable to repay the loan amount due to the heavy loss, but he want to resettle the loan amount under OTS scheme, Your Lordship. If the honorable court direct that I should appear before the bank and on the basis of the OTS scheme, the loan amount may be kindly be settled.
Are you aware about that Bapna Motors case? There lordships, Justice Chief Justice Chandrachud and Justice Padriwala, they have stated that this amended provision 13(8) makes it clear that the right of the borrower to redeem the secured asset stands extinguished on the very day of publication of the notice for public auction, and the right of redemption available to the borrower under the Indian statutory regime is drastically curtailed. So that is the provision 13(8). It says that it should not be entertained, and particularly when you have an alternative remedy available with you, challenge it in the BRP.
Your Lordship, liberty mechanism, so that I will approach.
Correct. This writ petition has been filed by petitioner Messrs. Gopal Traders, challenging the auction sale dated 26/9/2000 issued by the opposite party number 1. With a further prayer for settling the on account of the petitioner under OTS scheme. The auction sale notice has been annexed to the writ petition as Annexure 1. In the case of Seller LLP versus Bapna Motors Mumbai Private Limited and others, reported in 2024 Supreme Court cases 1, it has been held as follows. Quote paragraph number 110.3. Since the petitioner has got alternative efficacious remedy available, we are not inclined to entertain this writ petition. However, it is a petition to the bank for settlement, and it is up to the bank to consider this in accordance disposed of. Yes.
Item number 2.
Our presence mechanism.
I mean,
Yes.
I mean, GC, Your Lordship.
Please give your name and your.
I am in VC, my lord, in item 2. May I please, Your Lordship?
He is at level.
Yes.
I am in VC, my lord.
Yeah.
May I please, Your Lordship? This is regarding, my lord, pursuant to page 11 annexure 1, a tender was settled in my favor, Your Lordship, would find in annexure 2, page 15.
To come to your cancellation of a letter of award, that is annexure 5.
Yes, Your Lordship.
See the
There
reason.
they say,
Yeah.
reason is that I did not comply it within due time.
How it,
710, Your Lordship is looking at.
how it can be said to be an arbitrary order or irrational order?
Yes, yes. Why I am saying that, Your Lordship? Why I am saying that? The annexure 2 was issued on 21/9/2024, which I received in the late hour. That was, of course, on Monday I received because the next day was a Saturday, Sunday. and it was acquised no user was a Saturday. My lord, your lordship, kindly at this juncture may turn to page 13. 29.2 of the petition, my lord. The bidder shall within 15 days of issue of letter of acceptance, performance security, additional performance security, if any, in the form and the work program, and shall sign the agreement in prescribed format. 15 days of issue of letter of acceptance. If even if that they have explained in annexure 6, your lordship, 7 rather, my lord, in the last column, your lordship would see.
Annexure 7, they have stated that whatever explanation you have given, that is not acceptable, and they have.
Yes, I'm taking your lordship to that. I went to their office on 5/10 along with all the documents.
Yes.
And your lordship would find the drafts are at page 18 and 19, 3/10/2024. Fixed deposit receipts. 18 and 19, page 18, 19, 3/10. I went to their office on 5/10. As a mark of presence, I signed that page 22, your lordship. My representative signed it on 5/10. They did not accept it. And in any case, 29 days as per General Clauses Act, if your lordship would be kind enough to exclude the day of issuance, then also it falls on 6th. That I have given a typed copy, also clear copy, my lord, as page 23.
Whatever reason you are giving in that annexure 6 for not complying the that annexure 5 about that submission of ISD or FPS, whatever it may be, for execution of that agreement, they have explained in annexure 7 that how it is not acceptable. Now, in view of their explanation, some disputed things comes into fore. So how that can be decided in a real jurisdiction?
Yes, that your lordship may look at. Straight away, I will take your lordship to page 24.
Yeah.
Last column on the right. The LOA was issued on 21/9/2024. Your lordship finds that.
Yes, yes.
And as per clause 29(2) of the TTCN, which I was placing, my lord, maximum time limit to execute the agreement is 15 days, that is up to 5/10/2024.
Yeah.
I'm leaving it at that, your lordship. Now I had gone to their office, as I am showing your lordship in annexure 6, annexure 7. My presence I have noted in their register. It was on 5th. This is a copy of the register, my lord. My representative was there. I have given a typed copy. My name is at the last entry, your lordship. Type copy, it is page 23. And I had prepared this bank particulars.
Now you can comply all these things.
Yes, my lord, I'm still ready and I'm comply. I have ready with those, your lordship. At page 18 and 19, money part I'm having. Agreement, I had gone to execute the agreement.
Draft 3 page. Draft
Your lordship may kindly have a glance to the DTCN agreement. That is at page 13, 29.2. May I place it?
Yes, sir.
The bidder's
page number?
My lord, page 13 of the writ petition.
Yeah.
I'm referring to 29.2 at the bottom line. The bidder shall within 15 days of issue of letter of acceptance furnish performance security and additional performance security in the form and the work program, and shall sign the agreement in the prescribed format, failing which the engineer in charge shall, without prejudice to any other right or remedy available law, be at liberty to either he will suspend, prohibit, debar, blacklist from participating in the bidding in any contract of the state, or cancellation as per OPWD.
No, the liberty is with you. There is no problem. But if he is now ready and you have not proceeded further,
my lord,
we are just asking you.
4.
I have gone through that.
See, by 5th October he has to comply.
Yes.
By 3rd October he was ready with the drafts. So, is it not a compliance? Substantial compliance?
My lord, your lordship may kindly see annexure 3. Before expiry of 15 days, he approached the authority. Annexure 3, your lordship may kindly see.
Yeah.
Before expiry of the 15 days.
That is 39.
Yes.
39. Thereafter he took steps. 3rd October, before your time lapses, he has taken all steps.
But
and he complied with 29.2.
But he has taken
substantially.
But he has
The
taken
money has already been deposited. What do you want? Only security.
that security.
So that security has been deposited by 3rd October.
And those
Record shows
that Kisan Vikas Patra and other things, whether
No,
he has
you
prepared
are
with,
right to the extent that everything he has not complied with, but the main thing which my Planet brother is hinting at you that the amount that has been also ready, then other things, something has been left out. So take instruction if anything can be done.
yes, I'll take instruction. My lord, so far as the agreement is concerned, in case of failure on the part of petitioner, there is a condition stipulated in 29(2) that the award of contract will be given to the L2 subject to fulfilling the condition. Now a specific averment in para 13 of the writ petition, your lordship may kindly see.
Yes.
The petitioner has taken and also implemented the L2 as a party. That in the meantime, the petitioner has gathered the OP number 24 are contemplating to issue the letter of acceptance in favor of L2. So whether
it has been given.
Yes, yes, and
So
it
that
has also
instruction also
implemented them as parties.
right. No. If it has not been given, matter is different.
Yes.
If it has been given already, then obviously that party that he has already been added as opposite party number.
Yes, 5 and 6, I think.
So that instruction also you take in the meantime.
Work should not have been done. Work should not have been commenced.
Commenced, but if the award has
appearing for whom? Yeah.
He is my associate, your lordship. My instructions yet to be issued, your lordship. Puja holidays have intervened.
All right. This writ petition has been filed by the petitioner, M.S.Raman, with a prayer for quashing the later dated 7/10/2024 issued by the who has issued that chief executive.
That has been issued by
OP number 2.
Chief executive officer.
4, my lord.
Opposite party number 2. In forfeiting the bid security submitted by the petitioner in the form of fixed deposit receipt of rupees 53,000 issued by the bank as per the requirement of DTCN clause 27.2. Since 15 days after passing the issuance of LOA dated 21/9/2024, the petitioner did not submit the IAC and APS to execute the agreement as required in the LOA and clause 29.2 of DTCM. Mr. Storangle and senior advocate, to the attention of this court, the letter issued by the petitioner to the opposite party number 2, wherein the reply has been given to the letter of cancellation. That is interior work of our SCL office in 2nd and 3rd floor of ICCC building at Raurkela. The authorities have rejected the representation submitted by the petitioner by Annexure 7. Paragraph number 13 of the petition, it has been mentioned that opposite parties number 2 to 4 are contemplating to issue letter of acceptance in favor of AL2. The Land Council for the state submits that he has no instruction whether such letter of acceptance are issued in favor of the opposite party number 5 or not, and he may be given some time to obtain instruction and about the status of the contract. Put up this matter. Let it come on Tuesday. Then it will come in the supplementary list and will obtain the instruction. I'll put up this matter on 22nd of 2024. Instruction, if any, be obtained in the meantime. Yes.
Will it be proper on my part to address your lordship for protection, if any?
IN number so and so status was on to be maintained this till the next day.
Urgent copy, my lord, if it is possible.
Item number 3.
Mention that one extra copy is served on Land Council for this.
Wait, please. Petition is bona fide lessee manner. Having taken query after having bid at the highest rate. Then, my lords, abruptly, demand notice. Initially, they said that the crusher unit that was set up was purportedly lying within the forest area. So, therefore, my lords, there was an inquiry. In the inquiry, they said that no, it was most of the crusher site was within the forest area, but only a portion of it was found to be extended part was.
So, Palit, there is a standing order issued by this court on 24th September 2024. I hope that you are aware.
I'm not aware of that order.
It reads like that, relying on that Jaiki Singh versus Sarwan Sarma, issued by the Honorable Supreme Court. It is, I'm just quoting it, that before we part with this order, we may note that there is a growing tendency to plead law in so and so and to put decisions of this. I'm sorry. I think about 20 pages of your.
My lords, that by then this law had already been pleaded, and henceforth we will avoid. This will be avoided, my lords, henceforth.
No, please come to the second page of that third page of that writ petition. What order was passed in that the last one? W number 6083 of 2024. Page 3, please come to that.
Page 3.
Just so many writ petition number you have given. The last one is WPC number 6083 of 24, disposed of on 19/3/2024. What order was passed in that?
This 6083, my lords.
Yeah.
That was dismissed. And order has not been annexed. Order has not been annexed. So but that was on a different issue, my lord.
No. We just want, because you have given it relates to the petitioner's case that some order has been passed.
Tangentially, but not in this issue.
How can we know that what order has been passed, how they have deviated from that earlier order? So that
that does not pertain to this issue at all. That's a separate. This demand notice is separate one. It's a standalone proceeding. This demand notice is a standalone proceeding which is directly covered by your lordships.
No, that we know that was relying on.
That was dismissed. That, my lords, there was a road. The issue in that order was this, my lords, that the allegation was the petitioner was using a road, a forest road, for purpose of transportation of his ores. My lords, after the writ petition,
Mr. Das, you please come to that annexure 2022, which is challenged here. As it appears, you see that on 25/7/2024, these are the persons who visited that place that is under Bhapur Tahsil, and they found these are the irregularities that has been quoted in 1 and 2. Then straight away it is mentioned that you are to deposit rupees so and so, including so and so for penalty. And so, where is the opportunity of hearing?
No show cause, nothing. This is directly covered, man.
So that is exactly he is relying on a decision of this
very same bench, my lords. Page 183.
So yes, you have found some irregularities, but at that stage, you should have given some show cause or something like that to
I have an approved mining plan. Mining plan has been approved by the DDM, Director of Mines. I'm sorry, Director of Mines. And it was within
because,
the
on the straightway you have come that you are to deposit this amount. No opportunity.
And I was also not given a, my lords, I was also not given a, lessee was also not issued with the notice.
No, it's all right. Just find out that what is that order was passed in that WPC number.
I'll tell you, Lordship, my lord, that order. That order was
got that copy of that order. 6083 of 2020.
What's up?
Order passed in the consequential contempt proceeding.
No.
There at Annexure 17.
Not contempt. It was in the writ. Lordship is concerned on the writ. 6083. 6083, they said that the allegation is against individuals. So a company has filed a writ challenging the my lord's order of the government. So therefore it was dismissed. And thereafter the individual has filed separately.
Yes, WPC number.
6083 of 2024.
$6083 2024. And
I'm pulling out that order.
the order is dated 19/3/2024. Please share it so that they can also see. Mr. Das, please see this order.
This is no way connected to this.
Was the later dated change one of the opposite party and for 26 on it is and further six direction to the passing of the order dated side on it is 22. For clearing and for the order. The first one from the order. It's for goes to but my one gets from government actually have state and so that's one man but it's scroll down. Having hard line county
Having heard the learned counsel for the parties and after going through the records, represented.
But then okay.
So separately, my lords, that writ has been filed. It's pending. That is before the honorable single judge.
This is against this petitioner, Lacey, in that annexure 22.
This is the demand.
That means the petitioner.
My lords. Here, that has been separately filed, pending before the honorable single judge. That relates to my lords, Jungle Road.
It is relating to this stone coin.
Not this demand, neither the extraction. It relates to the allegation that a part of the forest land on which the road in which the trucks were being ferried over was transported belongs to the forest. The violation of the forest land. So that, my lords, we have filed separately because the honorable court on a technical ground said that we will not adjudicate because of this. That's pending before the honorable single judge.
This case relating to illegal.
This is relating to illegal raising.
Raising.
Demand raised on illegal mining operations. This is not.
It's not that when it's an administrative action, but cannot be without all that. Take notice, this petitioner, Venudhar so and so have filed this petition challenging the demand notice under Annexure 22 issued by mining officer is opposite party number.
Opposite party number 3. No, I'm sorry. Opposite party 7. OP 7.
7. Opposite party number 7. So, from Annexure 22, it reveals that on 25/7/2024, the mining officer Nayagarh, ORSAC team Bhubaneswar, DFO Nayagarh staff, Tahsil Bhapur staff, police personnel, and lease representative proceeded to Kasia Stone Quarry 1 under Bhapur Tahsil and noticed some irregularities, and accordingly the petitioner who is the lessee of the Kasia Stone Quarry 1 under Bhapur Tahsil has been asked to deposit an amount of rupees so and so, including TCS and penalty for the outside area, and so and so for inside lease area accesses. देखिए quote करिए है ना. The land counsel for the petitioner, which paragraph you are quoting about that principle of natural justice?
Minutes 38. Your Lordship's order is that I'm relying on your Lordship's judgment.
The land counsel for the petitioner.
Annexure 23.
That no reasonable opportunity of hearing has been provided to the petitioner before issuing Annexure 2022.
Referred to in this case Khali referred to.
And he has also referred to
184
the decision of this bench.
No, this bench I'm a Supreme Court.
This has been subsequently followed in this judgment also in by other benches.
In so and so you decision should have issue notice on the question of admission, indicating that the matter shall be disposed of at the stage of admission. The land counsel for the state accepts notice for all the opposite parties. So and so. Extra copies of the expedition will show.
I will delete minutes OP5 by mistake. Minute as a typo is the appellate authority.
The land counsel will start. Mr. Palit, land senior advocate.
I delete
oral submission to delete opposite party number
5. DDM Mines.
Deputy Director Mines, Jajpur Circle, Jajpur, from the cost title. Permission is granted. Let's say revised cost title, amended cost title for the revised cost title will file. IN number so and so, application for to issue notice, operation of the order dated so and so under Annexure the state till next date.
Great, sir. Urgent copy of your Lordship, sir.
Item 4.
My plea, Lordship, my lord, the most disquieting feature of the case, my lord, may I invite Lordship's kind attention, your Lordship's direction, my lord, to make deposit of 10 lakhs to the bank, my lord. I make the good payment. Despite that, my lord, the bank may invite Lordship's kind attention to the page, my lord.
You are challenging?
I'm challenging the order of the learned tribute DRT, my lord, as well as the illegal action of the opposite party bank, my lord.
DRT, which order you are challenging?
My lord. 27.
Huh?
27 24 order.
Yes.
Correct.
What has been held there?
That, my lord, the DRT said, my lord, you make further deposit 10 lakhs. When your lordship directed me to make a deposit of 10 lakhs, I deposited the whole amount, and the bank accepted the matter, that amount, my lord. Thereafter, what happened, my lord, bank again went for re-auction, my lord. Your lordship directed, if I made the payment 10 lakhs, that the bank shall not finalize the auction, my lord. When the matter was under the teeth of the lordship's direction, my lord, bank again floated a re-auction, my lord, which is all illegal, my lord.
So how can we entertain this one? And you have got section 18 of the SFSI Act. You can challenge the order before the appellate court.
That apart from since your lordship had directed that to make deposit of 10 lakhs, I paid, bank accepted. Then, my lord, to circumvent your lordship direction, the bank again put another e-auction sale notice.
Things are now again.
Yes.
That that sale notice has already been issued, and in view of that Bafna Motors, number 2, waive out your alternative remedy available before the appellate.
Bottom, correct, my lord. My humble submission, my lord, I again brought before the learned tribunal through amendment that the e-auction sale notice is illegal, since I have already deposited the 10 lakhs in pursuant to your lordship direction. Also, the DRT dealt with, your lordship found, my lord, or DRT dealt with that aspect. Despite that, over and above your lordship direction, the DRT said again you deposit 10 lakhs. That means 20 lakhs, my lord. Your lordship is total amount was 41 lakhs. Out of the 41 substantial amount, 10 lakhs I deposited. Your lordship's order may invite lordship's direction, my lord. Your lordship, the order is crystal clear. That is. Now, I've already challenged. I filed an application.
Filed the appeal.
No, modification. I filed an application for modification of the order before the tribunal. My lord, your lordship kindly pass. Invite us kind of page 32, very important. Page 32, para 17 of your lordship direction.
You have got sufficient time to challenge the order before the appellate tribunal. You have not gone. This order which we are challenging was passed on 25/7/2024, and in the meantime, almost 2.5 months have.
I filed an application for modification before the tribunal, because that pending, my lord. That is, my lord. While that application is kept pending, the bank said I protect the second re-auction sale notice and sold the property. My lord, that may be considered. That will do it. Your lordship direction.
Entertain this petition. However, it is said that a recall petition has been filed.
Modification.
An application has been filed for recalling of.
Yes. Under Annexure 7
dated 25/7/2020, passed by the DRT, and the same has been registered as IN number. What is that IN number?
Annexure 7. I has not
been filed by Annexure
7.
But the same has not yet been taken into consideration.
Yes.
And in the meantime, the bank has already gone for
second area auction sale and opposite Patnam.
My lord, with permission, my lord has passed the earlier order, the under read petition, that is pursuant to the auction sale notice dated 26/4/2024, fixed to 29/5/2024. That auction was failed.
Notice has been
failed. Subsequently, the auction notice by my lord has passed the bank issued a further notice, that is the 5/7/2024, fixing to 26/7/2024. In that case, my lord, the DRT loaner, DRT Kotak has categorically stated to deposit 5 lakhs in 2 installments within a stipulated time period. But they have not deposited.
Last portion.
So this is the order is also applicable for my lords 100% carried in view of section 18 of the Forfeiture Act.
Appearing for the Odisha Gramya Bank submits that since petitioner has flouted the order passed by which order he has flouted, he will say?
It's blood, your lordship direction. That 28 vacation. 28 24.
By this court.
By this court of your lordship's order.
The
28 24 milord. Summer vacation. 28 24.
The
Annexure 1.
Phrase auction sale notice has been issued on 5th July or what is that date?
Yes,
5th July 2024, fixing to 26/7/2024.
Fixing the date of auction to 25/7/2024.
Milord, fix it to 26, but the DRT orders
26/7 in view of the submission made by the land council for this one.
And this fully
auction has been held, milord.
And the auction has already been held and property has been sold.
24 lakhs 21,000.
Number 4.
In view of the Bapna Motors case, while not inclining to interfere with the order, influence order, since alternative remedy is available to the petitioner, if any such interim application is pending before the DRT and the same is moved, then necessary orders can be passed by the DRT to expedite the hearing of the interim application.
Lordship's order dated.
That is
yes, that repeated the amount.
Item 5.
Not then certified.
Here in this case, the petitioner participated in the auction, who stood as the second highest bidder, but in view of the violation of the condition 5 of the tender notice, the highest bidder case has been considered and he accepted his tender. But I have challenged this same acceptance before this honorable court, and this honorable court directed the opposition number 1 to consider my representation. And after considering my representation, opinion number 1 under Annexure 6, even though come to the finding that he has violated, highest bidder violated the condition 5 of the tender notice.
Mr. Bahali, please come to the operative portion of that.
Yes, page 31.
No, you come to page 32.
32.
This order was passed on 4/10/2024.
Yes.
And see the first paragraph, last line. Hence, executive officer is directed to float a fresh tender within 15 days hence. Whether that tender has been
no, that is for interim arrangement.
Whatever it may be, whether
interim
that tender, we just want to know from you whether
yes,
the tender has been floated.
They have floated it.
So why have you not annexed it? If you are having that.
After filing up my case, that is the.
You amend your writ petition, file that.
No, that is for interim arrangement.
Whatever it may be.
Now, may I read, my lord?
Yes, yes.
Before closing the discussion, it may be noted that the main rituals, Puja Dasara of the deity Mangala Kapuru is going on. In the event of closure of Dipo Dokan, the same could not be inconvenience to the devotee.
You can now participate in the tender.
So that is for interim period. They have said that you float fresh tender. Tender notice would be difficult to realize.
You have already received your caution money.
They have returned. So they have returned.
You are saying that you have accepted.
That draft is there.
You amend your writ petition and challenge that.
No, my lord, your lordship.
Writ petition has been filed challenging the.
That is an interim arrangement. I am challenging the non-acceptance.
Annexure 6, which is the order passed by the assistant commissioner of endowment dated 4/10/2024, Odisha Bhubaneswar. In the impugned order, it has been mentioned that the executive officer is directed to float a fresh tender in 15 days. When a query is made to Mr. Bahali whether any such fresh tender notice has been issued.
Fresh tender
That
is for जो period fresh tender होगा पर्यंत interim arrangement है.
See, interim arrangement को तो fresh आमे पच्चारू जो प्रश्न डा
fresh tender है.
Submits that correct. Fresh tender has not been floated as yet. Let the land and council for the state obtain instruction in that respect, put up this matter on 22nd October
Endowment
2024.
पे हो जाए cancellation
Huh?
endowment
And
cancellation
acha, Miss
I'm appealing.
yeah. So
Copy
Naidu
में भी served on it.
matter to 22nd October, and you take instruction whether any tender has been floated in the meantime or not,
Not
because 15 days is actually expiring tomorrow. All right.
not true. Again. Copy may be served. Copy the in hand.
Name of Miss Naidu be reflected in the cause list which is appearing for the endowment commissioner. Mr. Tahali supply copy of the petition to Miss Naidu in the meantime. Yes.
status quo में भी that fresh tender तो है ही
Yes. Now you see these pujas are going on.
नहीं interim चालची ना
Create any disturbance.
नहीं interim arrangement ଚାଲଛି ସେଟା fresh tender ହେଇନି
ଆପଣଙ୍କ ପୂଜାରେ କୌଣସି ବିଭ୍ରାଟ ହବନି।
नहीं नहीं ସେଟା fresh tender ହେଇନି
ଆପଣ ବର୍ତ୍ତମାନ ଏଇ ବୁଝାବୁଝି ସେମାନେ ଠିକ କରୁଛନ୍ତି। Wait for some time. Participate in the fresh tender. Yes, better. 22nd.
so my right will go if I will participate fresh tender.
Yes. ମାଙ୍କୁ ଟିକେ ଅଧିକା ପ୍ଲେଟ୍ ଦେଇକି ଟେଣ୍ଡର ପକାନ୍ତୁ। Yes, you will get it. Yes.
Item 6.
In this writ application, the petitioner sought for a direction to the opposite parties to issue work order to the petitioner who is successful L1 bidder in the tender call notice under Annexure 1 and
What
2.
you are challenging here?
This one, that is the inaction of the opposite party for not issuing the work order and not accepting the GST.
That you are challenging. Come to your prayer number 3, page number 12.
Yes, madam.
16/5/2017 order. You are challenging after
Yes,
almost 7.5 years.
Now what happens?
Because you do not know. Writ petition, if it is filed, inordinate delay in challenging a order without any explanation, nothing. How can we entertain this writ petition?
Ma'am, I am challenging the recent order, my lord, because
you are challenging this particular order. You see, entire prayer is the order number so and so be quashed 16/5/2017.
No, that is
what you are doing that from 16/5.
That is the order passed by the collector for blacklisting the petitioner organization.
Have you challenged earlier this particular order 16/5/2017?
No, that is never.
Then why will entertain it?
Because my prayer number 1, 2.
It may be your prayer. We are asking for the delayed approach to this court.
So far as prayer number 3 is concerned, that may be way out. 1 and 2 may be considered, my lord.
Yes.
But what happens in this case, my lord? The petitioner submitted the tender papers on 12th March 2024 before the collector Balangir. He was declared as the successful L1 bidder in the tender process, my lord.
Yeah.
And the petitioner quoted the 18% GST price on consolidated remuneration service charges in government guidelines, my lord. That has also been submitted before the collector Balangir, my lord. Now thereafter they have not considered my grievances, not signed the agreement, as also not issued the work order.
Something you have not bringing all the things. This was issued on 29/2/2024. Thereafter, what has happened? We are in October 2024. In the meantime, what has happened? You have not mentioned. Rather, you are challenging an order of 2017.
My lord, I made a repentation for issue of work order that has not been considered. Thereafter, approach this
after 29/2/2024. This annexure 2, you have to come to your prayer.
My lord.
Your prayer number, you are saying that number 3, I may leave it. Now you come to number 2. Number 2 is opposite parties may be directed to issue work order to the petitioner who is the successful L1 bidder in the tender call notice dated so and so, annexure 1 and 2. Annexure 1 and 2 are dated 29/2/2024. Thereafter, what has happened? You have not stated anything.
No, but they have approved this on court, my lord, in the writ petition, my lord. That is under annexure. That is the order passed by the Honorable Court earlier, my lord. That is under annexure. That is, my lord, under annexure at page 18, my lord. Annexure 4. And this Honorable Court directed the collector Balangir to dispose of my repentation.
That's right. Then what happened?
They have not taken any steps. Thereafter, I made a repentation on 30th September 2024 to consider my grievances and issue the work order, and my quoted GSTs may be accepted, my lord. Till date, they have not taken any action. I am the successful L1 bidder.
This
My performance also good.
annexure 10, you have not got any intimation from the authority.
No, madam. I never got any
Annexure 10 to dispose of period direction. Yes. All right.
Item 7.
Wait, please, Manoj. Now we turn to annexure 13, Manoj. Petitioner is a lessee. Now, regarding cancellation of the lease of Sankhari South New Building Stone, query Chaw, Kolapahar. Whereas you are selected as the successful bidder in respect of the Sankhari South Building query, that's at page Manoj 136. Kolapadar, basing on the notice dated 31/3/2017, whereas it is reported by the mining consultant that you have extracted 52,212 cubic meters of building stone during the year 22-23 from the above query illegally without depositing any royalty and other dues, CTO and blasting permission. Whereas for the excess excavation of 52,212 cubic meters, you were noticed by the SJTA, notice number so and so 28 dated 28/12/23, to deposit 3 crores and 24 lakhs within 15 days of receipt of the notice towards royalty, TCS, DMF, EMF, penalty, etc. But you did not deposit the same. Whereas you were noticed again on 2/8/24 to deposit an amount within 7 days, but you have failed to deposit, and the explanation rendered by you is not satisfactory. Whereas, as per the terms and conditions of the conditions, the watch and ward of the query is the duty of the successful bidder after the bidding process is over. If an illegal extraction is found, the same is chargeable from the successful bidder. Now, my lords, I never received, I have stated in my paragraph, my lords, I have pleaded, I never received this notice dated 28/12/2023. In my lords, conditions of my lease, my lord, that notice, there was no such my lords clause wherein it was mentioned that watch and ward, my lords, I'll be liable for the watch and ward. Rather, I have, my lords, furnished documents before in this and next to this writ petition that I had lodged a complaint, my lords, to the sub-collector that my quarry illegally is being operated by some mafias. Kindly take action, because you have not executed the lease deed in my favor. The lease deed was executed in my favor only in 2024, and the blasting license, March 24, and the blasting license was granted to me only in June, my lords, 20. Your lordship will see the last paragraph is even more interesting and, my lords, arbitrary and abrupt. In view of the above laches and violations, the lease of Sankhari so and so is hereby cancelled with immediate effect. Further, EMD dated 3,55,000 and 73 lakhs is hereby forfeited, and the leaseholder Srimati Devasmita Samantra is also blacklisted from participating in any future auctions. Further, rupees 3 crores 24 lakhs shall be recoverable as arrears of land revenue. Now, all this has been done, all the 3 punishments have been levied in one order. Your lordship may kindly come to my lord's writ petition. I have taken a specific pleading at paragraph 18. The impugned demand notice strangely indicates that the opposite party has served a show cause notice dated 28/12/2023, which is purported to be the first notice on which the authority has raised a demand so and so for alleged illegal excess extraction. In this context, it is most humbly and respectfully submitted here that the petitioner is completely unaware of the aforementioned show cause notice and has never such a show cause notice dated 28/12/2023. Now, my lords, your lordship may come to the lease deed. The annexure 1 is my notice. That is what they are relying upon. That clause, that stipulation, that watch and ward. Your lordship will come to this annexure 1.
No, this you have stated that you have received the notice dated 28/12/2020.
No, I have not received. I have pleaded, my lord. That notice was never served to me. I have pleaded on affidavit. that this notice was never served to me. This is my affidavit in my writ petition, my lords. I mean, my lords, I've filed an affidavit that I've never received that notice. Actually, may kindly come to page, my lords. There are several irregularities, my lords. Your lordship will come. This is only one.
Mr. Parit, you mean to say that this annexure 13
13
indicates about issuance of so many notices, like
second notice.
One notice is dated 28/12/2023.
Yes, that I never received.
Then you said another notice is 2/8/2024.
2/8, my lords, I have annexed. This notice I have received is annexure 10.
Yeah.
Page 131.
Yeah.
This does not talk about blacklisting. Why that is relevant, my lords? I'll come back to that, my lords. 2/3/2024. I have given a reply in annexure 11. Your lordship will see. With reference to the letter dated, that is at page 132. That notice I have replied.
2/8/2024.
My lords. Second notice. Second notice I have given a reply. Your lordship will see my reply. With reference to letter number so and so, I would like to inform you that the query, my lords, Sankhari Cha New Stone query under Kodapadar Mauja is being approved by the Odisha state government on March 2024. I never had the approval also. The blasting permission of the said query was approved in June. I form was also issued in the month of June. They issued me Y form in the month of June. Based on the above information, I would like to justify my statement that my query was operated illegally by some mafias or by some other people. I don't know, as I was staying out of India since 5 years and I was not even came to India even once during this period. In 17-18, when I was in India, I had given written complaint to the sub-collector Khurda, IAC Khurda, Temple Office Khurda regarding illegal mining, and complaint was also registered. I had given a complaint, and on my complaint, it was registered. The surface plan of the query was also submitted in the month of April. So after which the query was by me. If any fine will be applicable due to over mining beyond the allocated MGQ, then I will be responsible for that. Then your lordship comes to the next page, my lords. Annexure 12, page 133. Already 2 crore and 52 lakhs is there lying with them. I have given already, my lords, advance royalty of 1 crore 59 lakhs I have already deposited for a period during which I have not even mined one single or I have not raised.
Annexure 13. One thing is there that this leaseholder so and so is also blacklisted.
Yes, that they can't do. They can't do, my lord. The law is very clear in this judgment. Very clear, my lord. The law has been laid down. Lordship may kindly have a look at these judgments. The law has been spelled out. More coin. Page 2. I'll just read the relevant paragraph, my lord. Paragraph 21. I passed on the SEC reference. The central issue, however, pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind serving of a show cause notice is to make the noticee understand the precise case set up against him, which he has to meet. This would require the statement of imputations detailing out the alleged breaches and defaults he has committed so that he gets an opportunity to rebut. Another requirement, according to us, is the nature of action which is proposed to be taken for such a breach. That should also be stated so that the noticee is able to point out that the proposed action is not warranted in any given case. In the given case, even if the defaults or breaches complained of are not satisfactorily explained. When it comes to blacklisting, the requirement becomes all the more imperative, having regard to the fact that it is the harshest possible action. The High Court has simply stated that the purpose of show cause notice is primarily to enable the noticee to meet the grounds on which the action is proposed to be taken against him.
That show cause notice which was issued earlier, there is nothing about this blacklisting.
Nothing about the blacklisting. The first one I never received.
Second, you say that you received, but that was on the other issue, that why it should not be cancelled.
Why it should not be cancelled, my lord? There I have given the explanation that look, you never executed the mining, my lords, and your lordship may kindly appreciate. It was on my complaint, your lordship may kindly appreciate.
Yeah.
It was on my complaint that the police team was organized. Your lordship will see.
All right. The petition has been filed by the
Paragraph.
Srimati Devasmita Samant,
And I was not even in the country.
challenging the demand note 28/2024 under Annexure 13, wherein referring to the earlier two notices issued to the petitioner, that is dated 28/12/2023 and 2/8/2024. The impugned order has asked that for the laches and violation, the breach of Sankhari South New Building Stone Quarry CHHA 5 further is cancelled, and so and so was forfeited, and the leaseholder bracket petitioner was also blacklisted from participating in any future auctions, and further so and so they can be. Mr. Palit and senior admits that neither the petitioner has received the notice dated 28/12/2023 nor in the notice dated 2/8/2024 there is anything regarding blacklisting of the petitioner from participating in any future auction. Thus, the petitioner has not been provided with any opportunity and he has been blacklisted. He relies upon the decision of the Honorable Supreme Court in case of Gurkha Services versus Government in City of Delhi and others, reported in 2014 bracket 9 Supreme Court cases 105, wherein it has been held as follows. Court paragraph number 21. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of which are the opposite party you are?
1, 2, 3, and 6.
1, 2, 3, and
6.
6th.
Jagannath Temple.
Notice so far as 4 and 5 are concerned. Requisites for issuance of notice by speed post with proof of delivery shall be filed by 21st of October 2024. Matter with respect on such and such a 3-day interim application for stay as an interim measure. There shall be stay of operation of the order packet so on so by Annexure 13 until further orders. Yes.
Annexure 13.
One extra copy on sale.
Yes.
Annexure 13.
Yes, yes.
Great one. Urgent copy, if you lordship.
Item number 8.
May please, Lordship. Lord, here is challenge, Lordship, under Annexure 1. That's Annexure 1, the order of the appellate authority. And kindly see, Lordship, on your own admission, it appears on the face of the order, Lordship, as 27.
Mr. Alai, please come to that paragraph 21 of your writ petition.
21, Lordship.
Yes, page number 23.
Lordship.
Please read it out.
It appears action process takes place in 2021 and agreement has been executed in the 2023. Now, the virtue of the legal process, the opposite part number 6 has already been started operation, hence immediate interference is on highly variable.
What were you doing from 21, 23?
Lordship, I am continuously this release of 5 years. Lordship, kindly see immediately approach before the state government, ventilating the grievance, Lordship, because there is no proper publication, but the basic requirement of law.
No, last
under
time
rule.
you approved this court.
Lordship, kindly see I have written in the para because order, Lordship, my order disposed on 31 or 24, Annexure 1. And Lordship kindly see para Lordship kindly see page 11. And Lordship come to page 12, Lordship. However, the opposition did not consider dependence on the petitioner. The petitioner was constrained to approach this Honorable Court in writ petition number 34625 of 2022. This Honorable Bhai ordered 23/12/2022 directed the opposite partner what to consider the representation dated such and such and to pass appropriate order. Then Lordship I approached before the state government, and the next part I have given Lordship reminder to the state government that did not consider. Again I approached before this Honorable Court. Lordship kindly the last para H Lordship.
On filing representation after representation.
No, one representation.
Then come here. Then
no, Lordship. For us, I'm unable to convince.
yes.
One representation before the state government.
Yeah.
Which are not considered. I approached this Honorable Court.
Yeah.
Your Lordship directed consumer representation. They did not consider. Then Lordship kindly come to again. I approached this writ application before this Honorable Court, and your Lordship directed by order date 29/3/2023 to prefer an appeal. Because Lordship 46 speaks of any order, any person agreed by the order of the competent authority, he can approach before the appeal.
Yes.
Then Lordship preferred appeal, and this is the outcome of that appeal, Lordship.
Yes.
That is Annexure 1, Lordship.
Yeah.
Lordship, for a moment, can Lordship come to 27 rule 27 for a moment, Lordship. The 27(1) of the OMC rules, Lordship, for a moment.
We come to the influence order.
Lordship, that is the outcome of the 20, that is the clear deviation, and he is admitted. Appellate authority is admitted in his order sheet. Lordship, 27(1) speaks of there must be wide. There are the area of the core lease shall be delineated in notification, inviting applications for grant of core leases through auction shall be published in 2 daily newspapers, at least one of which the state level and other having been wide publicity in the area where the lease is located, and such notification shall be published at least 15 days before the intended date of inviting applications and shall contain the date and time within which application shall be received. So the basic requirement of law, Lordship, it has to be 2 newspapers, one in state, Lordship, and other in local area, only because wide publication and Lordship for wide participation, Lordship. Lordship, kindly see what he has done, Lordship, the competent authority. And Lordship, kindly the page 27 last paragraph, his own admission. The claim of the so-called appellant with reference to the publication of auction notice in 2 daily newspaper, it is to indicate that though the auction notice has been published in 1 daily leading newspaper, that is Samaj, and the copy of the auction notice has been published through NIS of Sundargarh district as well as RI office such and such, Calcutta, along with the government officers wide published, has been made. So he is justifying himself, Lordship, because once it has been made in 1 newspaper, it is qualifying the conditions as required under 27(1) of the rules, Lordship. The rules on the face of the document, Lordship, and my entire case from the day one, Lordship, because of you have never come up with wide publication, I could not participate, Lordship. And this is a hand in gloves. You are hand in gloves with the successful bidder and making a own arrangement with the nexus of the Lordship, the successful bidder. You have completed the bid. And Lordship, kindly the second objection he has made.
What is that rule? Let us see.
Lordship. 27(1).
I'm speaking.
Lordship, 27.
27.
1, Lordship. 27(1). May I read, Lordship?
Just a minute.
Lordship.
Yeah.
The area of the core lease shall be delineated and notification inviting applications for grant of core leases through auction shall be published in 2 daily newspapers, at least one of which shall be state level and other having wide publicity in the area where the lease is located, and such notification published at least 15 days before the intended date of inviting application and shall contain the date of the time which application shall be received. So the basic requirement law and the purpose of the statute enactment, Lordship, to make wide publicity and there is more participation, so that it can, in the purpose of augment of state revenue, Lordship. So the initiation of proceeding itself, Lordship, contradicts the rules, Lordship, which has been provided by the state government. And I have, Lordship, second point was the Lordship, and how they are handling laws with a person who is not qualified. The second country, they have allowed him, Lordship, and let's now see he's their Lordship.
There is nothing in the rule that if suppose it is published in one newspaper
Lordship,
and it is widely published in the areas as has been.
Area, no, not area. Area is not there, Lordship. The second department have not.
I just want to know from you because he stated
Lordship,
that it is published in one, but the copy has been published through NIC of this one. So these are the wild publicity has.
But it cannot be, Lordship. He can interpret the law which has been enacted by the state, Lordship. So that is the state all out of there are state basic newspapers and local newspapers.
Mr. What do you say? It requires two newspapers. How can we say one and the rest of the things?
Mandate of the rule, my lord. I will take instruction.
All right. This writ petition has been filed by petitioner so challenging the order dated 30/1/2024 passed by the sub-collector Pan Post under Annexure 1 in dismissing the appeal referred by the petitioner. Mr. Dalai Lama Council appealing for the referring to 227(1) of Orissa Minor Minerals Concession Rules 2016 submits that it is the requirement of law that the auction application for grant of lease through auction shall be published in two daily newspapers, at least one of which shall be a state and the other having wide publicity in the area where the lease is located. And such notification shall be published at least 15 days before the intended date of inviting application and shall contain the date and time within which the application shall be received. Mr. Dole submits that admittedly, in the case in hand, the auction sale notice has been published in one daily leading newspaper, that is Samaj, but it has not in the other newspaper which is widely published in the area. And it would be evident from the impugned order itself. However, the Land Appellate Authority has held that since the copy of the auction notice has been published through NIC of Sundargarh district as well as in the RI office Kalunga Public Tahsil office Lathi Kota along with all government officers, wide publicity has been made. According to the lake, this is in contravention of Rule 27(1) of the 2016 rules. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice for all the
except six. Except 6, Lordship.
Except opposite party number 6. Extra copies to be served on the Land Council for the state. Requisites for issuance of notice for opposite party number 6 will be filed by 21st October 2024. Issue notice on this interim application also.
One extra copy.
Mr. Dari, please hand over.
I'll start with Lordship.
Yes.
Any decision, Lordship, in the meantime, if
he is working now.
He is working, Lordship.
Yes, next.
Item 9.
My lords, I may please. This is an industrial dispute, my lord. This relates to industrial dispute, my lord. We are the petitioners working presently as industrial meter security guard under the employer, under the principal employer.
You have submitted a representation on 14/10/24.
My lord,
You have not got any response from the authorities.
no, my lord, we got the notice on 4th October through WhatsApp
I'm
message,
asking
my
you
lord.
that you have submitted a
Yes,
representation
ma'am.
on 14/10/2024.
1410, I
right?
submitted my
Sir,
application before the conciliation officer.
How do you expect that the authority during this Durga Puja vacation will dispose of that representation and you will straight file this representation and come and file the petition?
My lord, they have
no other one.
issued a letter to disengage on 20th October.
Mr. Counsel, you are, whatever your prayer is
My-
that, one of the prayer is that you have filed a representation, but when you are filing a representation on 14th,
My lord.
how can you file a writ petition on the very day,
My lord.
next day or after one day?
My lord,
that,
when it is an
my
industrial, it
representation has
relates
not
to an
been
industrial dispute, the conciliation will be held before the district labor officer. My lord.
representation filed, it is to be disclosed of the, give the time limit. And yes, next.
So, my lord,
Item 10.
Yes, ma'am.
Here, Lordship, also, Lordship, para, outside I am bringing Lordship's kind attention. Para 22, Lordship, I have stated it is yet to be.
Are you appearing for TPCODS?
Yes, but I had instructed to.
Which one?
See,
Please give the name so that we can mention.
4 and 3 and 4.
You will be appearing.
We are just mentioning your name.
Yes, sir.
Hard swan, so for the. Yes, item number 10.
10, Lordship. At the outset, I want to bring Lordship's kind attention. Para 22, here has stated it is still yet to be operated, Lordship, it is inoperative, Lordship, because want of environment clearance, they are not operating. But Lordship, kindly let us come to clause 4.6, rule 4.6 for a moment. They do.
No, auction process started in 2021.
21.
But it is not, that is why exactly we wanted to know.
Lordship, because Lordship, environment clearance is a requirement under law.
No, that is out.
Lordship, that is.
So the statement, whether it is correct or not, just take instruction, we can take up it on 22nd.
But Lordship, here, Lordship, kindly another state, Lordship, kindly clause 4.6.
No, let us, because in that case, you have mentioned it very clearly that he is now operating. But here we are also mentioning that very paragraph which you are referring to.
Lordship.
I've just sidelined that why it is took place on 2021.
Lordship.
Whether this statement is correct or not.
But Lordship, that's Lordship, that will be. But another part, Lordship, kindly.
Is Gram Panchayat
Lordship
was not granted.
Lordship. So this is the basic requirement law in
subject to
schedule area.
adjudication.
Like you know, in the writ petition, the petitioner so and so has challenged the order dated so and so annexure 1. In the paragraph number 22, it has been mentioned that though the auction process took place in 2021, but till today, that is the date of filing of the writ petition on 9/10/2024, it is inoperative due to environmental clearance. Stop. Mr. Mishra and Counsel for the state time to obtain instruction on this paragraph. Put up this matter. Let us come it next week. We can 22nd of October.
Ether notice probably Lordship decided ether
Compliance of Rule 4 bracket 6 of the
same notice
as well as compliance of Rule
4.6 Lordship.
4.6 of
Odisha minor
OMC rules 2016.
So and so 4.6 of the OMMC rules 2016. Data 22nd.
Lordship. Grateful, Lordship.